But the constitutional government of this island is so admirably tempered and compounded that nothing can endanger or hurt it, but destroying the equilibrium of power between one branch of the legislature and the rest. For if ever it should happen that the independence of any one of the three should be lost, or that it should become subservient to the views of either of the other two, there would soon be an end to our Constitution. The legislature would be changed from that which was originally set up by the general consent and fundamental act of the society. And such a change, however effected, is, according to Mr. Locke, who perhaps carries his theory too far, at once an entire dissolution of the bands of government, and the people will be reduced to a state of anarchy, with liberty to constitute to themselves a new legislative power. Having thus cursorily considered the three usual species of government, and our own singular constitution, selected and compounded from them all, I proceed to observe that, as the power of making laws constitutes the supreme authority, so wherever the supreme authority in any state resides, it is the right of that authority to make laws, that is, in the words of our definition, to prescribe the rule of civil action. And this may be discovered from the very end and institution of civil states. For a state is a collective body, composed of a multitude of individuals, united for their safety and convenience, and intending to act together as one man. If it therefore is to act as one man, it ought to act by one uniform will. But, inasmuch as political communities are made up of many natural persons, each of whom has his particular will and inclination, these several wills cannot by any natural union be joined together, or tempered and disposed into a lasting harmony, so as to constitute and produce that one uniform will of the whole. It can therefore be no otherwise produced than by a political union, by the consent of all persons to submit to their own private wills to the will of one man, or of one or more assemblies of men, to whom the supreme authority is entrusted, and this will of that one man, or assemblage of men, is in different states, according to their different constitutions, understood to be law. Thus far as to the right of the supreme power to make laws, but further, it is its duty likewise. For since the respective members are bound to conform themselves to the will of the state, it is expedient that they receive directions from the state declaratory of that its will. But since it is impossible, in so great a multitude, to give injunctions to every particular man, relative to each particular action, therefore the state establishes general rules for the perpetual information and direction of all persons in all points, whether of positive or negative duty, and this in order that every man may know what to look upon as his own, what as another's, what absolute and what relative duties are required at his hands, what is to be esteemed honest, dishonest, or indifferent, what degree every man retains of his natural liberty, what he has given up as the price of the benefits of society, and after what manner each person is to moderate the use and exercise of those rights which the state assigns him, in order to promote and secure the public tranquillity. From what has been advanced, the truth of the former branch of our definition is, I trust, sufficiently evident, that municipal law is a rule of civil conduct prescribed by the supreme power in a state. I proceed now to the latter branch of it, that it is a rule so prescribed, commanding what is right, and prohibiting what is wrong. Now, in order to do this completely, it is first of all necessary that the boundaries of right and wrong be established and ascertained by law, and when this is once done, it will follow of course that it is likewise the business of the law, considered as a rule of civil conduct, to enforce these rights and to restrain or redress these wrongs. It remains therefore only to consider in what manner the law is said to ascertain the boundaries of right and wrong, and the methods which it takes to command the one and prohibit the other. For this purpose every law may be said to consist of several parts: 1. Declaratory, whereby the rights to be observed and the wrongs to be eschewed are clearly defined and laid down. Another, Directory, whereby the subject is instructed and enjoined to observe those rights and to abstain from the commission of those wrongs. A third, Remedial, whereby a method is pointed out to recover a man's private rights, or redress his private wrongs. To which may be added a fourth, usually termed the sanction, or vindicatory branch of the law, whereby it is signified that evil or penalty shall be incurred by such as commit any public wrongs, and transgress or neglect their duty. With regard to the first of these, the declaratory part of the municipal law, this depends not so much upon the law of revelation or of nature, as upon the wisdom and will of the legislator. This doctrine, which before was slightly touched, deserves a more particular explication. Those rights than which God and nature have established, and are therefore called natural rights, such as are life and liberty, need not the aid of human laws to be more effectually inverted in every man than they are. Neither do they receive any additional strength when declared by the municipal laws to be inviolable. On the contrary, no human legislature has power to abridge or destroy them, unless the owner shall himself commit some act that amounts to a forfeiture. Neither do divine or natural duties, such as for instance the worship of God, the maintenance of children, and the like, receive any stronger sanction from being also declared to be duties by the law of the land. The case is the same as to crimes and misdemeanors that are forbidden by the superior laws, and therefore styled mala in se, such as murder, theft, and perjury, which contract no additional turpitude from being declared unlawful by the inferior legislature, for that legislature in all these cases acts only, as was before observed, in subordination to the great lawgiver, transcribing and publishing his precepts, so that, upon the whole, the declaratory part of the municipal law has no force or operation at all, with regard to actions that are naturally and intrinsically right or wrong. But, with regard to things in themselves indifferent, the case is entirely altered. These become either right or wrong, just or unjust, duties or misdemeanors, according as the municipal legislator sees proper, for promoting the welfare of the society, and more effectually carrying on the purposes of civil life. Thus, our own common law has declared that the goods of the wife do instantly upon marriage become the property and right of the husband, and our statute law has declared all monopolies a public offence. Yet that right and this offence have no foundation in nature, but are merely created by the law, for the purposes of civil society.